Yes, Ms. Ferguson.
My ladies, my lord, I appear on behalf of the Commissioner of Police, who is the appellant in this matter and is the defendant in the underlying action. Learned friend Mr. Brindle appears for the respondent and claimant. This is an appeal against an order made by Mr. David Pittaway KC, sitting as a Deputy High Court Judge on the 13th of February 2026. The order appealed against was a case management order, but one that had the effect of depriving the appellant of relying on any witness evidence and therefore of defending itself at a trial that was due to commence on the 23rd of February of this year. I come to the perhaps difficult issue of housekeeping because I understand that there's been some confusion over bundles. It seems like a lot of work has been going on in the last 20 minutes or so.
Well, look, don't worry too much about that. We understand it's not the party's fault. They filed amended bundles and they didn't reach us. I think what would help us is if, when you're referring to documents, you refer by page number rather than by tab.
Yes.
And then hopefully it will all line up.
Yes. I may end up doing both, my lady, just because that's the way I've organised it. But yes, I've got the page numbers anyway, so I'll do that. Can I just for completeness though, check that you should have, in any event, a core bundle running to 150 pages, a supplementary bundle running to 303 pages, and an authorities bundle running to 202 pages. In terms of procedural chronology, I'll just quickly run through that, if I may. Permission was granted by my lady, Lady Justice Whipple, on the 19th of February 2026, and the order is at Core Bundle, tab 1, page 2. As well as granting permission, my lady ordered expedition with any respondent's notice and in any event the respondent's appeal skeleton argument to be filed by the 27th of February of 2026. We took from that the permission to appeal skeleton of my predecessor in the case, Mr. Claimant, would be treated as the appellant's appeal skeleton. The respondent duly served a respondent's notice. That's at Core Bundle 8, starts at page 72. It's not dated, but there's no issue about that being in time. The salient parts of that, for present purposes, are at page 76.
Okay, mine's not one I've worked up anyway. It's not paginated. I'm sure I can follow where you are, but I've got internal pagination from the RN.
Right, so it's internal pagination 5.
Yeah, thank you.
I just want to double check, my lady, it's that the pagination of the bundle is really faint in the bottom right-hand corner. You haven't got
for
that.
some reason, we're on the respondent's notice.
Yes.
I haven't got any.
Right.
But I've marked up the out-of-date bundle, so I'd rather stick with this if I
yes,
can.
of course. Well, the lady will tell me if you're not following. And so that respondent's notice has given rise to the listing of two, as I understand it, separate applications with separate application numbers attached to them, namely for an order about the abortive trial costs and the claimant's application for strikeout of part of the witness statements. I'll come back to that in a moment, but just completing the procedural chronology. The respondent also filed and served a witness statement in support of the respondent's notice. That's at Core Bundle 9, starts at page 81. And the respondent also served his appeal skeleton argument, and that's at Core Bundle 10, starts at page 97. I should also have given you the start page for the permission to appeal and the appellant's appeal skeleton, which is Core Bundle 4, starts at page 54. So there are three matters then before the court today. The main appeal against the judge's order of the 13th of February. should the appeal be allowed, the respondent's contingent application for strikeout of part of the defendant's witness statements, and in any event, the respondent's application for an order in relation to the abortive costs of the trial. My ladies, my lord, we've had a discussion at the bar this morning about the application for strikeout in relation to the witness statements. Our view, subject to the court's contrary or better view, is that that is a matter preeminently for the High Court. We thought it unlikely this court would want to delve into that application, which is a standalone application.
Well, very sensible. I mean, it's the sort of thing that you would expect the trial judge to deal with if there is a trial.
Exactly so. So there's not really going to be much for us to deal with on that.
The only issue, I think, the bit that, to pick up what my lady said, I understood that the application was that if it was remitted, if the issue of strikeout was not dealt with by us and there was going to be a trial and it was remitted to the High Court, I understood the application to be that there should be a freestanding hearing in front of the High Court judge to determine it in advance of trial. And I think the answer to that on your side is no, let the trial judge deal with it. So we may just need to tackle that in due course.
My lady, that's exactly the issue, yes, that remains. So turning then to the appeal, and just if I can make some introductory observations about that. There are 3 grounds of appeal, and the court will find those in the core bundle. Tab 2 starts at page 16. But taking our case on appeal globally, and by way of overarching points as an introduction, can I say this? Firstly, the order under appeal was made in response to an application made by the defendant, which was on its face an application for an extension of time for the service of witness statements. There is no dispute that the defendant submitted the application to the court electronically prior to expiry of the extant deadline, and that the claimant was informed almost immediately thereafter that the application had been filed. At the hearing before the judge, something went badly wrong in relation to the characterisation of that application. And this court, I submit, will need to consider how and why that happened.
Well, one explanation is the fact that for reasons that at the moment we haven't been able to explore, the sealed copy of the application notice wasn't in the bundle.
Correct.
If it had been in the bundle, it would have been blindingly obvious that it was sealed on the 4th, not the 5th. And we probably wouldn't be here.
Well, I certainly don't think my learned friend would agree that we wouldn't be here, in the sense that, or put it this way, that wouldn't
we'll
be...
obviously hear what he has to say about how he says something can't be issued on the date on which it's sealed, but on the face of it,
yes.
It was sealed and issued on the 4th.
Yes. Well, I'll come to the respondent's position in just a moment, if I may. Could I just complete the overview, and then I'll come straight on to that. We say, whatever the reason was, and we will look at how and why things went wrong, as well as the fact that the sealed application notice wasn't in the bundle. There are other factors to take into account as to the journey, if you like, from CCMC up to and including the hearing before the judge. But because of the mischaracterisation of the application, it was determined, we say, on the basis of the wrong legal test, that is CPR 3.9 relief from sanctions, instead of simply the overriding objective. And that's our ground 1. Further, that meant that the judge's decision was unjust due to a serious procedural irregularity. That's our ground 2.
So it's not a procedural irregularity, it's a substantive irregularity, isn't it?
Well, I think that's ground 1.
Yeah, well, right. I mean,
Yes,
in a sense, ground 1 is everything, isn't it?
It may be. I have organised my submissions to meet those 2 slightly different ways of putting it, but it may well be, and as my lady will have seen, they're sort of taken together in the appeal skeleton anyway. But in any event, whether on the test that was applied by the judge or on the test that we say should have been applied, the judge's refusal to allow an extension of time with the consequence that the defendant was unable to rely on any witness evidence and therefore to defend the case was plainly wrong in all the circumstances of the case. So wrong, we submit, that it fell outside the judge's admittedly wide case management discretion. In short, and for reasons I will develop, the outcome was out of all proportion to the defendant's default, and that is ground 3. Coming on then to the respondent's position, and there is an update in this regard, because Milena Friend informed me just as we came into court this morning that a concession is now made on behalf of the respondent in relation to the date upon which the application was filed, sealed, issued, made, whatever verb one wants, depending on which rule one is looking at.
We could write many pages on that very
Yes.
issue, couldn't we?
But in any event, that is conceded as a matter of fact and law. And I think that means, I've checked with Milena Friend, just so that we're very clear on what remains between us. Looking at his skeleton argument, which is at Core Bundle tab 10, starts at page 97. And if I can draw your attention to paragraphs 3 to 5, and here this is the summary of the respondent's response, and 3 to 5 incorporate 3 separate arguments in opposition to grounds 1 and 2. The first is the point that it was unavoidably an application for relief from sanctions, even if it was filed in time. That is a point that is maintained, I understand.
Really?
Yes.
Okay.
Sorry, say that again. So they're still saying
So that it was.
we do have to look at that. It was
Even
a
if
relief.
you file an application in time, you've got to ask for relief from sanctions, Mr. Brindle.
My lady, yes.
So that's maintained. The second argument at paragraph 4 is that, in essence, well, the relevant information wasn't before the learned judge, so you can't blame him for doing what he did. That's maintained, and that's, I think, probably the main battleground in grounds 1 and 2. And thirdly, then at paragraph 5, this is the point that's abandoned, that the assertion by us, and this is a sort of the objective assertion, knowing everything that we know now, that this was an in-time application is not made out. The application was filed and issued and so made after the deadline. That is abandoned. And likewise, if there's a few more paragraphs, which means that you can effectively disregard, and I've checked this with Milena Friend, he agrees. Firstly, paragraph 29, page 107.
Just pause a second. Can I just keep I mean, it may be for you, Ms. Bentham, maybe for Mr. Brindle. I've got it noted down that there's an agreement that the application was in fact made on the 4th of August.
So there is now an agreement.
Yes, there is
Yes.
now.
Yes, there is
agreement.
now. Exactly.
Common ground. This application was made
Yep. Filed, issued, sealed,
on the 4th of
etc.
August. Is that right?
Would it assist if I address the court? Would it assist if I address the court?
No, can I ask you my questions?
Yes.
So
No,
that
in
mine's
answer to the question about what I'm agreeing to or not
Is
agreeing to.
that agreed then? 4th of August.
So the stamp on the application that itself is dated the 5th of August.
Yeah.
The date of issue from the stamp is the 4th of August.
The date on the application was the 5th of August. I think that's the date the solicitor puts in, isn't it?
It's written on, yes, but the actual
The date stamp
is the 4th of
is the
August.
4th.
And I accept that is the day upon which the application was issued, now that I have seen
Okay.
that sealed copy of the application.
Okay. What I wanted to ask you then was, does it follow that you accept that it was made in time, or are you taking a point about whether the 4th of August was in time or not?
So, the 4th of August, if it had been made before 4 p.m. on the 4th of August, which it looks like it was,
Yeah.
then it would have been in time.
It wasn't. Okay.
So I accept as a matter of fact now,
Yeah.
it appears to have been made in time, but that was not clear at all.
Yeah, understood.
It was actually conceded in front of the judge.
All right,
that it
let's
wasn't.
have the argument.
Yes.
Got all
Sorry,
that.
sorry.
Okay, thank you very much, Mr. Brindle. That's fine for me. Thank you very much indeed.
And just the other paragraphs in the respondent's skeleton argument that therefore fall away. Paragraph 29 and also over the page 35 through to 40 inclusive.
35.
Yeah, there may be some other stray paragraphs that no longer apply, but those are the main ones. I am bound to observe that it is extremely disappointing and somewhat frustrating that this concession is made this morning, particularly since correspondence has been exchanged between the parties over the last couple of weeks in which we suggested that there'd be a narrowing of the issues to not trouble the court with things that could and should be agreed. And that point was the lion's share of that invitation.
When was the sealed copy of the order made available to the other side?
Well, that's a good question, my lady, in this sense. It was on, as I understand it, was on the CE file. Now, what we don't know is the point at which it was uploaded to the CE file. But obviously the CE file is available to both parties throughout the proceedings. What we can say for certain is that by the time that our application for permission to appeal was lodged, we had alerted the parties to the existence of a sealed application notice bearing the court stamp. I just want to check that I'm absolutely right.
Well, the way that it works, as I understand it with electronic filing, is that you will get an automatic date stamp put on it when it's filed. That's how it's supposed to work.
Yeah, you should be able to tell from the CE file precisely when the sealed order was uploaded, surely.
Well, that's a whole other can of worms because, and this was something that was introduced by the respondent since we got permission, and it's actually referred to in submissions before the judge at first instance as well, and that is that for some reason the court file at the time of the hearing has a sort of slightly strange way of recording what happened because it says, it gives a submitted date, so it says submitted on, and then it says filed date. And bizarrely, the submitted date is the 4th of August, and the filed date is listed as the 5th of August. Yes, so that was available to the parties at the time, and I think that has caused a great deal of confusion at the time. But we say that when we sort of caught our breath and looked at all of this in slightly slower time and located the sealed application notice, we say the position was absolutely clear and one was never going to be able to look behind that. Everything pointed towards it having been properly made for the purposes of 23.5 prior to the deadline, so made in time.
It may be that the confusion is because my recollection of the electronic filing order is that it talks about the date of issue and filing as being the same date.
It does. And the other confusion, milady, which we perhaps won't need to get into because of this concession, is that when you look at the electronic filing rules that were in force at the time, and this is slightly different from their current form, there's a slight anomaly in that the concept of issuing doesn't seem to be applied to application notices of this type. So the concept of issue seems to be related to claim forms and originating processes, which this wasn't. No. And so it is a bit of a mystery, but certainly that seems to have been slightly tidied up in the current version of the practice direction at 5C. But then, of course, there's the other question of whether any of that actually matters when one looks at Rule 23.5, which talks about an application being received in the court office and that being the time that it is, quote, made. And I think this was the point that Milady looked at in Senior COVID.
Yes.
In a different context, relating to the Practice Direction 7. And I think, as I understood the court's conclusion there, it was rather left as an open question whether actually the filing rules really impacted in any event on the Practice Direction 7, which is sort of the equivalent of the 23.5 in this scenario.
Well, the practice direction was supposed to reflect what the court had said on an earlier occasion. The only issue in Siniakovic was whether the failure to pay the full fee had any impact on the date for limitation purposes.
Yes.
And we decided it didn't, but we said it was undoubtedly it was made and filed
Yes.
in accordance with the practice direction.
Yes, yes. So those are perhaps now a number of loose ends that we or alleys, I won't say blind alleys, but alleys that we don't need to go down, hopefully. But as I say, this was, we say it is extremely unfortunate that this has only been made this morning. Now, what I want to do in terms of the structure of my submissions, if I may, is I need to spend a bit of time taking the court through the agreed chronology and showing you some of the documents that underpin it, because as I said, the way that events unfolded up to and including the hearing is critical to all three grounds of appeal. So there is a fair amount of groundwork that I need to lay first, and then I will come on to deal with grounds 1, 2 and 3 in turn. Finally, there's a few words to be said about the costs of the abortive trial, and we've already dealt with, and I'll say a few words about the strikeout application for witness statements and how that should be dealt with. So the agreed chronology, my ladies, my lord, is at Core Bundle, tab 5, page 61. And can I flag at the outset the 2 points that I propose to develop as I go through the chronology? The first is the fresh evidence issue that's raised in my learned friend's written submissions, because, and we've established that this point is maintained, he contends that we need the court's permission to rely on fresh evidence in the form of the sealed application notice in order to make good the point that our application for an extension of time was made in time. We say that is not the case. In fact, there was sufficient evidence already before the judge on the 13th of February, notwithstanding the absence of the sealed application notice, to resolve that question in the defendant's favour. So that's overarching point 1. And it leads on to...
But your fallback, presumably, is you say it's a matter of record and it would fit Ladd and Marshall anyway.
Yes, it would. Sorry, I'm sorry.
I mean, presumably you say, well, it would be just and convenient for this court to look at it, because the reality is it was issued in time, and you can't overlook the fact that on the court record it is quite clear that it was issued in time.
Yes.
And it's now conceded that it was issued in time. So to say, well, the court can't look at the obvious evidence, which is that it was issued in time, is not really in accordance with the overriding objective, it seems to me.
No, and frankly, if I'd known about that concession, I might have slightly reordered my approach to this. But
I had understood the objection was to the Sadie Seabrook witness statement and the timings when things were sent and received and the emails and da-di-da.
yeah,
You can't... is there a suggestion that the sealed application notice, which is on the court record, is itself fresh evidence? Because it's not. It's a document on the court record.
yes, I think that is the suggestion.
No, my lady.
I think Mr. Brindle
No,
is saying
absolutely
no.
not. I've
Right.
already conceded that the court can look at the application.
Right, so
it's
it's the
Sadie
witness
Seabrook
statement.
witness.
And now that has fallen away as to when actually it was issued,
That may not
quite a
be
lot of
true.
my objection doesn't really
Yeah.
right.
Thank you very
Fair
much.
enough. Well, we needn't spend too much time on it. We've read the witness statement de bene SA, but
Yes. Well, I mean, as it happens, I say we don't need to go there. And I'm not. I say that in any event, there was enough before the judge, and I'll piece that together for you.
do you really think you need to now? I mean, since Mr. Brindle has very helpfully indicated that it was made on a particular date, and that the court record can be looked at, do we really need to go into whether there was enough evidence before the judge about it?
Well, perhaps not, but I think my learned friend's point, just going back to his skeleton,
I don't want to take you out of your course,
No,
but
no.
it seems to me that if it's unnecessary, we perhaps don't need to spend a lot of time on the chronology.
no. Can I just go back to, so core bundle 10, tab 10, page 98. And you'll recall that I took you through the essentially 3 planks of the opposition.
Yeah.
Paragraph 5 being abandoned, but paragraph 4 is the factual evidence on which grounds 1 and 2 are based, namely that this was an in-time application, was not before the learned judge. Now, I'm told by Mr. Brindle that that submission is maintained. And so I think I do need to deal with whether the learned judge got it right on the evidence in front of him, irrespective of the sealed application notice. If that is abandoned, then I can cut out quite a lot, but I don't think it is.
Ms. Fenton, there are 4 entries on the chronology for the 4th of August,
Yes.
page 62. Is it your understanding that any of those 4 entries are controversial?
Well, no, because this is
Or,
agreed.
sorry, in terms of, yeah, it's an agreed
An
document.
agreed.
Can you not simply work, can we not all work from those 4 entries?
Yes. Yes, well, I would say yes, but as I say, I think Mr. Brindle's point is that grounds 1 and 2 shouldn't, so there's a separate argument about this was always an application for relief from sanctions anyway, regardless of that it was in time.
Yes.
We park that because
Yep.
we know that's completely separate.
Yep.
But the other argument is, as I understand it, grounds 1 and 2 aren't made out, i.e. you can't find that the judge applied the wrong legal test because he didn't have the information before him to work out that this was not an application for relief and therefore should have been dealt with as an application for an extension of time under the overriding objective. That submission, I understand, is maintained against me, quite apart from the first one. And so it seems to me I have to address the court on whether grounds 1 and 2 should be made out, or are made out, on the basis that the judge applied the wrong legal test to an in-time application.
I see.
And that precisely because there was information before him that should have led him to that conclusion. I think I have to go through that.
Okay.
And therefore, just coming back to my second overarching point as we go through the chronology, how and why it went wrong. Because if the evidence was there, as we say it was, to show that the application was made in time, why wasn't that identified? Well, as my lady said, one answer is because the sealed application notice wasn't in the bundle, but another answer, and the main answer as a matter of practical reality in my submission, is that this whole issue of whether the application was in time or not only became a live issue at the 11th hour, more specifically at 3:50 p.m. on the eve of the hearing, when the claimant served a skeleton argument in which it was asserted for the first time that the defendant's application was not made until the 5th of August, and launching full-blown opposition to an application that over the preceding 6 months he had expressly and impliedly indicated that he was neutral on.
I'm afraid that's not correct at all. Not over the preceding 6 months.
To be clear, my calculated the 6 months from the 4th of
Okay,
August through to the
Yes, we
30th of
haven't
February.
expressed any.
For my part, what would be, it struck me that everything went a bit wrong at the hearing because the Met's own barrister at the time had rather invited the judge to look at it on on an either-or basis, and actually that's not the case that you're putting on appeal. You're saying there wasn't an either-or, it was
Yes.
an in time.
I mean, that is right, my lady. But what I am trying to explain to the court is how that came
It
about.
blew up very late in the day.
Yeah.
Okay.
Certainly it looks to me from paragraph 2 of the judge's judgment on page 68 that the judge has said, I don't need to decide the issue as to the date. There is an issue as to the date on which the application was made, but that's not the right date. The right date is the date of issue, which was after the date when you were directed to serve the witness statements. Therefore, we're into CPR 3.9 territory. Now, if it's a matter of legal analysis, that's wrong, and the right date is the date on which the application is made, he should have grasped the nettle and decided when it was made.
Yeah.
And he knew there was an issue. You're
Yeah.
saying, well, there was information before him which would have been entitled him to come to the conclusion that it was made on the 4th, which is now conceded.
Yes. Yes, that is my position. But insofar as my Lady Justice Whipple rightly reminds me, that there was a concession
Yes.
effectively by counsel for the Commissioner, I submit that it's important for this court to understand, if that be in any way a bar, it is important for this court to understand how that came about.
Yes.
And one has to look at how this was dealt with from August onwards. I'm not planning to go through things in great detail, but it's just a few documents to take the court to.
Yeah.
So, story starts with obviously the order of Deputy Master Fine. For your reference, that's at Supplementary Bundle tab 1. Don't need to turn that up. Everyone's agreed. That directed the service of witness statements by the 7th of July 25, and it was subsequently extended by agreement between the parties to the 4th of August 25. And there was then some correspondence between the parties on the 1st of August, and an account of that correspondence was included within the witness statement of the claimant solicitor, Mr. Riley, and that was his statement dated the 16th of December 2025, and that is at Supplementary Bundle, tab 9, page, starts at page 31. If I can show you page 36. This was before the judge on the 13th of February. Can I invite the court to read to itself paragraph 29 to 31 of that statement?
Paragraph 31, really, isn't it?
Yes, I mean that's also a bit curious because it says at paragraph 31, defendant made an application on the same day, which at first blush might look like the 1st of August, but I think it must mean the 4th of August because that's the deadline day.
Can I ask you a point of detail? Which
Yes.
I read this before, and I probably should know the answer to this. But is there something about parties can agree extensions only up to 28 days but not beyond?
Yes.
So that was right to say I can't agree the 2 months that you're asking for. You're going to have to issue an application.
I mean, I think, one moment I might have to
So
check.
if somebody could come back to me, it's not material.
Lady, CPR 30, 3.8, so paragraph 3 and 4. CPR 3.8 provides that if there's a time limit that sets a sanction for not complying, the parties can only agree an extension of 28 days.
It doesn't mean obviously that the parties can't agree it.
It doesn't say that. The parties can't agree. It literally says you can't.
But look, I don't want to get into that one. It says that's exactly the point that I wanted to know about. It's probably a detail, but what the claimant solicitor was saying is I couldn't agree it even if I thought it was a good idea because I was precluded by the rules. And I don't think it's material to the argument line now, but it's just a detail I quite like to know
Perhaps
about
we'll
at some
come
point.
back to it.
Please, yeah.
Thank you. Yes, So we've looked at 29 to 31. And then just planning back, sorry, if I could ask you to keep one finger in the agreed chronology as well, because I keep coming back to that. The events of the 4th of August that my Lord has already alluded to. So 11:03, defendant emails a draft order, asks the claimant to confirm their position before 4 p.m. that day. That's the deadline. 2:45 p.m. defendant files the application. Court confirms the filing. 2:53 p.m. claimant serves his written statements under password protection. Those are never looked at until later. And 3:03 p.m. claimant served with the application and told this has been filed that day. Turning then to the application notice itself, this is at Supplementary Bundle 3, tab 3, page 10. And as we've already made clear, this version of the application notice was not the version before the judge. He had the version without the court's seal on it. 3 features to note about this application notice. Firstly, as we know, it's dated in error, the 5th of August, that's the solicitor's error. Secondly, it is made on notice to the claimant, that's at box 9. You may have picked up on points taken in a number of places, both by Mr. Riley in his witness evidence and my learned friend in submissions, about this application having been made without notice. That is simply wrong, and I understand is a submission that's retracted. And thirdly, that the defendant asked for the application to be dealt with without a hearing, box 5. Returning to the chronology, as we see there after the 4th of August, there's no response to the application from the claimant, either substantively or in terms of the mode of determination of the application. And so it has to be assumed, we submit, that the claimant was content in principle for the court to proceed to determine the application on the papers without the benefit of any submissions from the claimant in opposition to it. Similarly, when, as we see from the chronology, the defendant subsequently served its witness statement on the 17th of October, and that is when exchange took place. And that was in accordance with the extended date that had been sought in the application. At no point was taken by the claimant. And in fact, the first time anything at all was said by the claimant by way of response to the application was in the claimant's own application of the 18th of December 2025. And that is an application notice that you will find at Supplementary Bundle, tab 8, page 26. And it was perhaps first and foremost an application for an order pursuant to CPR 31.22, which doesn't trouble this court at all, but also an application for, if you look in the box at 3, the last line, directions requiring the defendant to serve revised witness statements. And there was a witness statement in support of that application. That's at the next tab. It starts at page 31. And if I can ask the court to go to page 41, please, of that statement, 41 of the bundle, and look at paragraph 57, where the claimant solicitor deals somewhat fleetingly with the defendant's application of the 4th of August, and says, four lines down in paragraph 57, the claimant's stance is neutral on the application in principle, subject to their point about it containing inadmissible evidence. And then they go on to say the claimant cannot point to any prejudice he will be caused by the late service. The defendant responded to that application by a letter dated the 6th of February 2026, find that in Supplementary Bundle tab 12, starts at page 183. And if I can draw the court's attention in particular to the second page of that letter, under the heading 3, Defendant's Witness Statements, and just invite the court to read those first 3 paragraphs.
Seventh of August.
That's wrong. It's the 4th of August. That was a typo. That letter was in the bundle before the judge on the 13th of February. But perhaps more importantly, the defendant served a witness statement responding to the claimant's application. And that's at Supplementary Bundle, tab 14, starts at page 188. Now, as you'll see from the agreed chronology, this statement was filed at lunchtime on the 12th of February. This is the day before the hearing, which is due to start at 2 p.m. on the 13th of February.
Sorry, just go through that again. That's filed on.
Filed at lunchtime. I think it's 12:58.
Got it. Okay, sorry, I'm back in your chronology.
Yeah,
Got it.
12:58 on the 12th. So this is Ms. Seabrook's witness statement in response to the claimant's application. And if I can ask the court to look in particular at paragraph 16, which is page 191, and ask the court to read paragraph 16.
CPR 32.10.
I think that's the
Sanction.
that's the sanction. So 32. I think it should be
It should be 3.9.
3.10. 3.10. Yes, not 3.9.
3.9.
Not 32.
3.
Yeah. Yes.
There's a certain amount of inaccuracy in everybody's witness statement. I mean, the one thing you didn't show us was that the master's order, I've just reminded myself of,
Yes.
says in terms that if you don't serve your witness statement by the specified date, you won't be permitted to rely on that evidence at trial. So there is a sanction in the order.
Yes. Absolutely, and that's why, if the application hadn't been made in time, the sanction would have been incurred. But the application was made in time, and so it was an overriding objective application rather than a 3.9.
That's your point.
Yeah.
I mean, I think that I now understand Mr. Brindle's point, which is that on the language of 3.8, paras 3 and 4, that's not right if there's a sanction in the order.
That, I think, is the point, but, well, as we'll come on to,
Yeah.
that's been dealt with by the courts already,
Yeah.
Hallam States in particular.
Yeah.
And Denton. So, now that statement that I've just referred the court to, paragraph 16 of which I've asked you to read,
Yes.
that was before the judge, and in fact, and I don't think we need to turn it up, but if you, in the hearing transcript, we can see that the judge expressly confirmed that he had read that statement. I'll give you the reference for where that appears in the hearing transcript. Supplementary Bundle, tab 18, page 244. So the position 24 hours before the hearing before the judge is this. Firstly, the defendant had put evidence before the court that its application for an extension of time was made in time and was not therefore an application for relief from sanction. The claimant, secondly, the claimant had impliedly, through his lack of response to the application and expressly in the witness statement of Mr. Riley of the 16th of December 25 at paragraph 57, confirmed that the application was not opposed and that the late service of witness statements had caused the claimant no prejudice. Thirdly, both parties knew that the application had in fact been filed before 3 p.m. on the 4th of August. Fourthly, the fact that the application notice was erroneously dated the 5th of May had not been identified or in any event addressed.
5th of August.
I'm so sorry, yes. I'm doing it now. And no one had said anything about what was recorded on the CE file. It follows then that the volte-face in the skeleton argument that was served by the claimant at 10 to 4 that afternoon was remarkable. And that skeleton is in the supplementary bundle at tab 15. And I just want to show the court one or two paragraphs in particular of that skeleton.
We're in the supplemental bundle, are we?
Yes, it's yes, exactly. Tab 15.
I have no tab numbers.
Yes, page 217.
Thank you very much.
And if I can ask the court to turn to page 225. And at paragraph, oh, I'm so sorry, that's not right. It's page 224, sorry. Paragraph 21, second sentence, the parties had agreed an extension until the 4th of August. The application was not made until the 5th of August.
And that's also repeated in para 23.
Exactly. It's also said in para 23 that's without notice, but I've already dealt with that. That's been accepted. That wasn't right. At the same time, though, the skeleton appears to proceed on the basis that it must be an application for relief from sanction in any event, and that's the point that we've canvassed to some extent this morning already. Paragraph 9 of this skeleton, page 219. And so what this skeleton completely ignores is, firstly, the letter of the 6th of February from the defendant's solicitor to the claimant's solicitor, where Miss Seabrook said that she'd issued the application on the 4th of August. Secondly, the statement of Sadie Seabrook that had been filed earlier that very day, which reinforced both the timing and the legal basis for the application. And thirdly, and perhaps even more concerningly, these assertions flew in the face of the facts known to the claimant's solicitor, namely that notwithstanding the erroneous date on the application notice, it was in fact filed on the 4th of August, because he was told as much at 3:03 p.m. on the 4th of August. Moreover, this skeleton argument sets out full-blown opposition to the defendant's application on all 3 stages of the Denton test, takes points that had either never been taken at all by the claimant's solicitor, or if they had, such as in relation to the conduct of disclosure, they hadn't been taken in support of, as part of opposition to the defendant's application, or as part of a submission that the defendant's conduct of the litigation as a whole had been poor, and that they shouldn't therefore have permission to rely on any witness evidence at all. And so that is why I started these submissions saying that the main reason for the confusion that characterised the discussion about and the judge's approach to the timing of the application and the applicable legal test is that this only became a live issue right at the end of the day before the hearing. And there was, unfortunately, very little time or opportunity for the defendant to respond fully or properly to the myriad points for the first time in this skeleton argument. I pause here to note what prompted the change of position by the claimants at such a late hour. And it was candidly admitted by my learned friend in front of the judge that it had been prompted, frankly, by the issue of the defendant bringing disciplinary proceedings, which you'll have picked up in broad terms from the papers, I imagine, in connection with the claimant's approach to disclosure. And at this point, if I can briefly take you to a part of the hearing transcript, so it's supplementary bundle, tab 18, page 250. And I'm at B on that page. And 3 lines down from B, this is Mr. Brindle, says, I will address the apparent change of stance head on. The claimants are perfectly entitled to change their stance. And quite frankly, when the defendant starts using its own documents that the claimant was required to disclose to it in these proceedings in order to initiate disciplinary proceedings against him, circumstances change. And this brings me to the defendant's position statement. And that's the tab before in that bundle, and it starts at page 237. Now this, as per the agreed chronology, this is filed at 9:54 a.m. on the morning of the hearing.
So you've got a skeleton from the night before.
Yep.
And now you've got a position statement that comes in just before the hearing.
Exactly.
Okay.
And at 2.1, Mr. Clements addresses what he refers to as the 4th-5th date dichotomy that had been raised for the first time in the skeleton of the previous afternoon.
Sorry, where are we at this?
So 2.1, sorry my lady, 2.1. He says the application was filed by a CE file 1446 on the 4th of August, within, albeit at the end of the agreed extension period. It was shown as accepted on the 5th of August. But given the 4th-5th date dichotomy, and to avoid unnecessary argument, the court may want to approach this as an application for relief. And so...
Oh, that's a bit strange. Either it's an application for relief or it's not an application for relief.
I mean, that must be right, my lady. I can't...
As such, this may not strictly be an application for relief. No, it isn't. It was made in time.
I mean, my lady, I can't get around that.
In order to avoid unnecessary argument, the court may wish to approach it as if it's something that it isn't.
Yes, I mean,
Right.
I think, I don't know, but it smacks to me of an attempt at pragmatism. But
Yeah.
that's just my interpretation of it. The court will have your own. Now, you'll note here that there's a reference to it was shown as accepted on the 5th of August. Now, there's no illumination of what that meant, either in this document or in front of the judge. It might be something to do with the document that we've seen since, which I was referring to in answer to the question of my lord, about the submitted by, filed by. I don't know, I'm speculating. But anyway, that's what this position statement says. And obviously, it did bear the date erroneously of the 5th of August. In any event, what has happened here is that the erroneous date recorded on the application notice, the record on the CE file, whatever that said, whatever Mr. Clements was looking at, and not himself having had sight, obviously, at that point of the sealed application notice, seems to be what's led him to this position. And then we look, and this is my final document before I come to ground one, at how this was all approached in the oral submissions before the judge. And for
Just
that...
pause there. Okay, sorry, they've got where I wanted to get to. Sorry, yep, go on.
That's in supplementary bundle, tab 18, the starts at 241. And if I can ask you to go to 244. And I'm at F, Foxtrot, Mr. Clements. Can I just address, oh actually the line above that is where the judge confirms that he's read Ms. Seabrook's statement filed that day. Then Mr. Clements, can I just address further please what your view might be on whether you want to look at this for an application for relief? It is borderline time-wise, or whether you want to look at it as a time extension. And then the judge said it is a relief application because it wasn't issued until after the 4th of August. Mr. Clements, yes, it was made, but that's why it's perhaps better to assume, given the issue, that if we treat
that again betrays what the judge has said. He's treating the date of issue as the key date. Well, it's not.
Agreed, and also, I mean, it's further confused when you look at the order. But if I just complete this little section, he says, Mr. Brindle will correct me if I'm wrong, the application was issued on the 5th of August. Mr. Brindle says that's the date on the application. And then there's some, it's not when the application, there's some cross-talking, and basically...
Presumably Mr. Brindle was trying to explain to the judge at that stage that it was filed the day before.
Judge, I was unaware of it, but that's the problem. We didn't have the sealed application notice. What I was actually saying to the judge, I remember the exchange well, was we're not looking at the day when the application was made, we're looking at the day when the statements were actually filed, which is why we get they weren't until October. Yeah. Because that's the key, is what I was saying. I wasn't concerned with the date of the issue application.
Yes, I mean, I think what we can take from that is that there's no clear answer to that. And then, as my learned friend quite rightly has identified, he's in any event fallen back on his central submission, which is it's an application for relief anyway.
Yeah.
So it's not really clarified there. So that is how it played out. Turning then to ground 1, which is that application of the test in CPR 3.9 was wrong in law. And if I can then ask you to go to the approved judgment, and this is at Core Bundle, tab 7, it starts at page 7. And what led, so I think what we can take from this, I'll come to the detail in a moment, is that Mr. Brindle's point about this is an application for relief in any event was not referred to and doesn't appear to have been relied on by the judge. That doesn't appear to be the basis upon which he decided that this was an application for relief and sanction. Instead, he's interested in the dates. And so at paragraph 2, he says, second sentence, although there is some issue as to the date on which the application was made to the court, it's common ground that the application was not issued until the 5th of August, after the deadline. And then he says, further down, and this is a contradiction, paragraph 4, second sentence, defendant's application, as I have said, was made on the 5th of August. And issued on the 5th of August. So it's not even it's not even very clear on that.
But what is clear is that he's treating the date of issue as the key date.
Yes. Yes, which is wrong. And in fact, that suggestion or assertion that finding that it was common ground the application wasn't issued until the 5th of August doesn't in fact reflect what was said by the defendant in the position statement or by anybody in oral submissions that we've just looked at. As far as I can see, it was never conceded by the defendant that the application wasn't issued, whatever that may mean, until the 5th of August. The most that was said by the defendant was what we saw on the position statement, that it was shown as accepted on the file on the 5th of August. And then the confusion about this is further demonstrated by the slightly different way in which the point is recorded in the judge's final order. And that's at Core Bundle tab 6. page 64. In the recital, the first part of the recital, says upon the court considering the defendant's application dated the 5th of August, but received by the court office on the 4th of August, which is of course the wording of 23.5. And then paragraph 1 over the page, paragraph 1 of the order, then it says the defendant's application for an extension of time is refused. So there, it's actually described properly, but not the way the judge approached it.
This is presumably because counsel had charge of the drafting of this order and was able to impose in the order a recital for the judge's consideration.
Yes,
Yes. I'm sorry, I took carriage of the order, and the draft I sent to Mr. Clemens was markedly different to this one. He sent back this draft. There had been no contention for issue for appeal or permission for appeal or for any of this significance now placed on the terms of the order to be contended for. Agreeing an order is supposed to be a transactional relationship between barristers. I agreed it. There seemed to be no point.
Thank you.
In my submission, all of that in Mr. Brindle's explanation just shows how confusing this all was and confused. And I keep coming back to it. It's because this didn't arise at all until 3:50 p.m. the day before. So, as I say, coming back to our point, that the relevant information was before the court, and I've already taken you to these, but just to recap. First of all, there was the witness statement of Mr. Riley of the 16th of December, paragraphs 29 to 31, which the court has looked at. Then the witness statement of Miss Seabrook of the 12th of February, filed at lunchtime that day, paragraph 16, which the court has looked at. And then there's the further information, such as it was from the CE file, referred to in the defendant's position statement, that the application was filed electronically at 14:46 on the 4th of August. So on that basis, on that factual evidence that was before the judge, as a matter of law, the application was made in time, in accordance with CPR 23.5. And as I understand it, the only part, so the respondent now accepts that that is the correct legal analysis, but it didn't until this morning, but still doesn't accept that the information was there, available to the judge to form the correct legal conclusion. But because the legal analysis is now agreed, I am not intending to go through any of the provisions in the electronic filing rules or anything like that, or any other provisions in the CPR, if that is an agreed position. Instead, I'm going to deal with the submission that does remain on the part of the respondent, that this was unavoidably an application for relief from sanction, simply because the witness statements were not in fact served until after the 4th of August. And in my respectful submission, this is simply a bad point. The position to be adopted as regards in-time applications for extensions of time was decided by the Court of Appeal in Hallam Estates and Baker. That is in your authorities bundle at tab 4, and it starts at bundle page 47. And if I can just, I've sidelined the passages at paragraph 2 and a couple more places. If the court could just quickly read those paragraphs just for the facts of this case. So paragraph 2, 11 and 14. And the ratio is to be found at paragraphs 26 to 28. So an application for an extension of the time allowed to take any particular step is not an application for relief or sanctions, provided the applicant files his application notice before expiry of the permitted time period. This is the case even if the court deals with that application after the expiry of the relevant period. And so at 27, it follows that the cost judge in this case was dealing with an in-time application. It was a straightforward application to extend time, and the principles concerning relief were not applicable. And at 28, it behoved the cost judge to deal with the application in accordance with the overriding objective. There is a suggestion in my learned friend's skeleton argument that Hallam Estates was wrongly decided. And he draws attention in that regard to the fact that the case was decided before the law was restated in Denton. Well, that's right, but the fatal flaw in that submission is that the Court of Appeal expressly endorsed Hallam Estates in Denton. And we can see that in Denton, which is Authorities Bundle, tab 5, page 75 of the bundle. At paragraph 82, where the court says useful application of the Mitchell guidance has already been given in some of the authorities to which we've referred at paragraphs 14 to 20 above. We hope it will now be unnecessary to refer to earlier authorities. Now, if you go back to paragraph 20, we see that part of the, or one of the authorities that the court was expressly endorsing there was Hallam Estates.
Yes.
And just for the context, you can see at paragraph 19, there was reference to the preceding case of Chartwell Estates, which is the well-established authority for failing to serve witness statements, failing to serve witness statements and not having made the application in time. It's dealt with as a relief from sanctions. The other authorities that are cited by my learned friend in support of his submission on this matter, in my respectful submission, don't assist him either. And in fact, they demonstrate the opposite of his submission and reinforce the rationale underlying Hallam Estates. That's illustrated in particular by a point that's made by Lord Justice Burse in two of the cases in the bundle. First of all, in the Lufthansa case, that's at Authorities Bundle tab 7. And if I can ask the court to turn to bundle page 127. And just three points there in the sideline part of paragraph 22, where Lord Justice Burse says many kinds of application for an extension of time in cases of breach do amount to applications for relief from sanctions, such as an application for an extension having failed to serve witness statements in the time ordered. That's Chartwell Estates. And then if you go down to D of that paragraph, if a sanction is in effect either as a result of the express terms of a rule, PD or order, or by implication, then relief is required. But if not, not. And then Chartwell is given as the example. And then down to paragraph 23, and under F for Foxtrot, the Lord Justice Burse says, back 3 lines down, however, the characteristic feature of applications for relief from sanctions is the fact that the application arises in circumstances in which the sanction is already properly in place and the applicant is seeking to disapply it.
Which was the case in Chartwell.
Exactly. And then refers to Mitchell on an application for relief from the sanction. Therefore, the starting point should be that the sanction has been properly imposed and complies with the overriding objective. And then over the page to 25, it is this aspect which distinguishes a relief from sanctions application to which Denton applies from a different application governed only by the overriding objective. And that really, that same point, that distinction is reiterated in the case of Yes A Electrical, which is at your tab 8 of the authorities bundle. Bundle page 136, this is Lord Justice Burst again at paragraph 12, where he says, I agree, an application to serve late factual witness evidence after the deadline has expired is one for relief from sanctions because, as explained in Chartwell, Rule 32.10 operates as a sanction for that failure to have served a witness statement in time. And so, in my submission, that argument goes nowhere. So, to sum up on ground one, we say, firstly, it wasn't properly open to the judge to apply the test under CPR 3.9. Rather, the application should have been dealt with as an in-time application governed only by the overriding objective. And we say it's not necessary for the appellant to rely on or seek permission to rely on new evidence on appeal to make good that point. The argument is made on the basis of the evidence that was before the judge and not what might additionally have been put before the judge. That, therefore, is ground one. Turning then to ground two, which is at least ostensibly of a slightly different character to ground one, namely that the learned judge's decision was unjust due to a serious procedural irregularity. Well, I've already referred to the key conceptual distinction between the two types of application as expressed by Lord Justice Burst. There was no appreciation of that distinction in the learned judge's judgment. He treated it squarely as a situation in which the application hadn't been made or issued until after the deadline, and therefore one in which the sanction was already in place, and the defendant had therefore to persuade the court to disapply it. Although it is somewhat unclear from the approved judgment to what extent the judge ultimately relied on this, he does refer at paragraph 3 of his judgment to submissions made by my learned friend about deficiencies in Ms. Seabrook's witness statement. And if I can ask you to look at supplementary bundle tab 18, page 248, which is the hearing transcript again. This is something that seems to have attracted him in the course of argument. Page 248. And I'm looking at H at the bottom of that page. I think her second statement shows a failure just to appreciate the nature of the application, because it doesn't go into any proper detail to answer the questions. I mean, she won't have had Mr. Brindle's skeleton argument, but really, to set out a chronology, I mean, I would have expected there to have been a chronology of the actions that she's taken to get the statement prepared. And if I may say so, I think it is a lazy way of producing a statement to deal with the issue as to whether or not there is good reason. But of course, the judge was considering that from the perspective that this was and should have been approached by Miss Seabrook as an application for relief from sanction, which was wrong. And when we get to the ratio of the learned judge's decision, sorry, I'm dotting about a bit here, but the judgment is at core bundle, tab 7, page 68. Paragraph 8. Sorry, it's page 6. No, it's paragraph 7. The judge says, essentially, he gives two reasons for refusing the application. Firstly, that he considered the litigation not to have been conducted efficiently and proportionately. And secondly, notwithstanding the draconian effect that his ruling would have, that there was an overriding need to emphasise the importance of the CPR being enforced. That is, I suggest, a paraphrasing of the ratio of this decision at paragraph 7. And that, unsurprisingly, given that it was what the judge said he was doing, demonstrates an approach being taken which chimes exclusively with Rule 3.9 rather than the overriding objective. And if I can ask the court to go back into Denton, please. Authorities Bundle, tab 5, at page 68. And I'm referring to paragraph 32. And what the court was considering here was the way in which Rule 3.9 singles out the two factors A and B. A being for litigation to be conducted efficiently and at proportionate cost, and B to enforce compliance with rules, practice, directions and orders. And what the court says in relation to the to those features and the test as a whole in 3.9 is, if you the court looks up 3 lines up from C at paragraph 32, although the two factors may not be of paramount importance, we reassert that they are of particular importance and should be given particular weight at the third stage when all the circumstances of the case are considered. That is why they were singled out for mention in the rule. It's striking that factor A is in substance included in the definition of the overriding objective, and factor B is included in the definition of the overriding objective in identical language. If it had been intended that factors A and B were to be given no particular weight, they would not have been mentioned in Rule 3.9. In our view, the draftsman of Rule 3.91 clearly intended to emphasise the particular importance of these two factors. I accept, of course, that the ethos of Denton is subsumed within the overriding objective and vice versa. And we see this expressed in particular by Lord Justice Coulson in the case of Jalla and Shell International. That is at Authorities Bundle, tab 6, starts at page 80. That was an appeal against the refusal of an application for an extension of time, not for witness statement, something else. And if I can ask the court in particular to look at paragraph 30. Three zero.
Sorry, para 30 of what?
Of Jalla and Shell International, Authorities Bundle, tab 6. So at 30, when considering applications of this sort, and as I say, this was application for extension, not relief, this court is obliged to take careful account of the overriding objective, and that's set out. And then at paragraph 32, down the page, I agree that the regime under 3.9 as to relief from sanctions is not directly applicable here, because there was no sanction, there being no failure to comply. Also accept that in many cases where an extension of time is sought to comply with an existing order of the court, the relief from sanctions regime will not be relevant. But I consider that the approach in Denton is of some relevance when considering the particular circumstances of this case. And he sets those out. And just jumping down a few lines, he says no extension of time in this case meant no continuing claim for the vast majority of these claimants, just as if the order had been an unless order. Accordingly, it says, it seems to me that the general principles identified with Denton are applicable, at least by analogy, when considering the application of the overriding objective to this case. An examination of whether the claimant's failure to meet the earlier orders of the court was serious and significant, whether there was a proper explanation for those delays, and consideration of all the circumstances of the case, is a useful and illuminating way of arriving at an answer to the question as to whether or not it was in accordance with the overriding objective to grant the claimants a further extension of time. That's, I can't get behind that, and I don't seek to, but none of that changes the fact that application of the overriding objective requires the court to balance a number of factors, including enforcing compliance with orders, but also, for example, ensuring the parties are on an equal footing, can participate fully in proceedings, and witnesses can give their best evidence. And in any event, there was no consideration by the learned judge in this case, as there was by Lord Justice Coulson in Jalla, as to whether, and if so, how, the Denton principles should, in the particular circumstances of this case, feed into application of the overriding objective. Because, of course, he didn't do that, because he was simply applying the Denton test. So he had no regard whatsoever to the overriding objective or any of its constituent parts beyond the two factors singled out in Rule 3.9, which, as is highlighted in the passage at Denton that we looked at, in fact, there's not a direct read across in terms of the dealing with matters of proportionate costs. That's what 3.9 says at factor A, whereas what the overriding objective says is dealing with cases justly and proportionately. May not be much of a difference, but there isn't, it's not a complete overlay. So for those reasons, in my submission, ground 2 is made out, the serious procedural irregularity being the application of the wrong legal test, and the injustice arising from that being that the defendant should have had the benefit of the more wide-ranging test of the overriding objective, particularly when the defendant had at all times approached the application and its own evidence on the basis that it would be determined pursuant to the overriding objective and not the narrower, stricter test in Rule 3.9. Ground 3. Ground 3 is that there was an improper exercise of discretion on the part of the learned judge. I accept, of course, that the appellant bears a heavy burden in persuading this court to overturn a judge's exercise of discretion on a matter of case management. The relevant principles are, in fact, conveniently referred to in the Jalla case, so that's back at Authorities Bundle, tab 6, page 91 of the bundle, and for your reference, paragraphs 27 to 28, and in short, as rather summarised at 28, the court can only interfere with the decision of the lower court if the judge had regard to a factor that was irrelevant or failed to have regard to a factor that was relevant, or if the judge's discretion was, quote, clearly, wholly, wrongly exercised, unquote. To the extent that grounds 1 and 2 succeed, I rely on the fact that the judge had regard to an irrelevant factor, namely Rule 3.9, and or disregard for a relevant factor, namely the overriding objective. But more than that, whether the applicable test was 3.9 or the overriding objective, in my submission, the judge was clearly wholly wrong to refuse the extension of time for the reasons that he gave. In fact, as we've already seen, his reasons are scant indeed. We've already looked at paragraph 7, which is really the sum total of his reasoning. And there, as we've seen, he stated a conclusion that the defendant's conduct of the litigation fell, quote, below the level which one would expect competent litigation to have been conducted. The reasons that are then given in paragraph 7 for that conclusion are really to refer to my learned friend's submissions, not to rehearse them, but just to refer back to them. So therefore we have to look back to piece this together to paragraph 5 of the judgment, where those submissions are outlined, but they're scantily described. It refers to submissions about tardiness or failure to comply with directions of disclosure and to the service of witness statements, and additionally to comply with directions for questions to the claimant's medical expert. One gets no sense of the details of that alleged tardiness or non-compliance that led the judge to his conclusion that the conduct of the litigation was effectively incompetent. With great respect to the learned judge, that is not good enough, given the damning nature of that conclusion, and that he was in effect making a terminatory ruling, and he knew it. Quite apart from the lack of proper reasons, in my submission that conclusion was wholly unjustified. To describe the defendant's conduct of the litigation as incompetent was overly harsh and not a fair reflection of what happened. What happened, and you'll have this primarily in the papers and in the agreed chronology, was this. There was communication with the claimant solicitor about the need for a further extension in advance of the deadline. Not very much in advance of the deadline, but it was in advance. It was on the Friday before the Monday. And the submission of an application in advance of the deadline. The need for a further extension was explained. Essentially, logistical challenges of setting up in-person meetings with all of the witnesses in circumstances where the evidential issues couldn't adequately be dealt with through remote meetings. And we've seen the evidence about being about to take down, and that's a central issue in the underlying action. There may well have been cause for criticism of the defendant for not acting more promptly, or not explaining in more detail what had been done thus far, or what remained to be done, or for not being more proactive in ensuring that the application was determined at an earlier date. But in my respectful submission, that does not fairly attract the label of incompetence, and particularly not when the claimant hadn't indicated that there would be any objection to the application. On the issue of disclosure, which seems to be the other main plank of the judge's reasonings, insofar as it can be discerned, it must be remembered that the defendant had no notice whatsoever that complaints about the defendant's conduct of disclosure would be deployed against it in the context of an application for relief from sanctions. Now, it is true that complaints were included about disclosure in Mr. Riley's witness statement of the 16th of December 2025. And those were addressed, albeit very briefly, in Ms. Seabrook's statement in reply. But that was all in the context of the claimant's application under 31.22 and about the inadmissible content in the witness statements. And those were never going to turn on the claimant solicitor's complaints about the defendant's general conduct of disclosure. So in my submission, the defendant hadn't had a fair opportunity to respond to those complaints in the skeleton argument, in context. And the judge should have taken that into account. And incidentally, we see in the hearing transcript, and I'll give you the page references in a moment, a couple of occasions where Mr. Clements makes it very clear to the judge that they had been taken, that the defendant and he had been taken by surprise by the skeleton. The page references are supplementary bundle 247, tab 18, page 247, and page 253. In any event, the position was, and this emerges on the papers, disclosure was provided in the first instance by the agreed date, the extended agreed date. Thereafter, some further disclosure was provided promptly upon it coming to the defendant's solicitor's attention and in line with ongoing disclosure duties. The service of additional disclosure later in the day had no impact on the witness statements. There was no need for the claimant to seek to amend his witness statements as a result, which is obviously the main concern about late disclosure, because obviously taking it out of sequence. And it hadn't put the trial date in jeopardy. And those factors weren't acknowledged in the judge's reasons. But more than that, just standing back and looking at this case more broadly, this was a case that was trial ready and due to be tried in 10 days' time. All of the witness evidence had been served by the middle of October 2025. That was some 4 months in advance of the trial listing. The claimant had, on his own admission, suffered no prejudice whatsoever from the defendant's failure to meet the 4th of August deadline for the statements. The claimant had no objection to the admission of his experts' responses to the questions put by the defendant, notwithstanding those questions weren't put by the deadline set in the CCMC directions. The claimant's opposition to the application was only revealed by way of a complete volte-face on the eve of the hearing, and it was prompted by the disciplinary issue. It was the epitome of opportunism. All of these factors, I submit, weigh heavily on the other side of the scales from any shortcomings on the part of the defendant. And so against all of that background, the judge's characterisation of the defendant's conduct of the litigation as incompetent was, I respectfully submit, unjustified. And in any event, the refusal to allow reliance on the witness statements was out of all proportion to the defendant's default. Those submissions are a fortiori if I succeed on grounds 1 and 2, and the judge should have been applying the overriding objective. But even if he was right to apply the Denton test because he didn't have the relevant information, I would maintain the submission that his discretion was clearly wholly wrongly exercised, because even on the test in Rule 3.9, it was still necessary ultimately to weigh up all the circumstances of the case to enable, as the words of 3.9 say, a just disposal of the application. And the judge's decision in my submission was the very opposite of that. And for those reasons, I submit that ground 3 is made out. Just a few final points then on the other applications. In terms of the costs of the aborted trial, in line with the submissions I've made on the appeal, the appellant's position on the abortive costs of the trial is that they are attributable to the claimant's unreasonable objection and last-minute objection to the application for an extension of time, and should therefore be borne by the claimant in addition to the costs of the appeal. That just flows on from my submissions on the appeal. So far as the application for strikeout of parts of the defendant's witness statements is concerned, our primary position on this was, and something that we said in correspondence to the claimant in the run-up to this appeal, that that was a matter which really was more appropriately dealt with by the trial judge, potentially at a PTR, but certainly by the trial judge if possible, rather than justifying a standalone listing. That said, and just to be completely transparent about this, when we were told by the court office, this court office, that that application had been listed, we said, well, that rather throws out potentially the time estimate for the appeal hearing, and given the uncertainty over the time estimate, in order to avoid that difficulty, we would be prepared to consent to it being remitted to the High Court in front of a hearing. So it wouldn't, in truth, then we didn't have a response to that. So it's perhaps slightly reneging on that, but we would say that really and truly this should be dealt with at the outset of the trial or by the trial judge rather than warranting a separate application. But that is perhaps detail.
I thought there was a suggestion somewhere on your side that the right time to deal with it actually was by the trial judge after hearing from the claimant and evidence, and that you then have a good grip of of what was coming and what the issues were likely to be and so on.
Yes, I mean that's probably right, my lady. I think I'd missed that, but that's probably in Mr. Clement's skeleton argument in front, or position statement is probably where that was said, or perhaps in correspondence.
Maybe it was in the transcript.
And yes, I mean that also seems sensible. I don't know.
But I think the judge said it. I think the judge said it.
Yes.
I think it's in the transcript, and it's of the hearing.
Yes, that
quite late on.
I think that's right. Yes. Unless I can assist you any further, those are my submissions.
Thank you very much. Yes, Mr. Brindle.
Please, my lord. The legal point, I submit, that troubles this court is when does a sanction apply? There are clearly two sanctions that should have, and I submit did apply, to the late filing of witness evidence. But the submission for the defendant, I'm going to refer to them as the defendant, is that because they got a stamp on an application notice before the deadline, those sanctions did not apply. That's what I submit the legal issue in this appeal comes down to. Whether or not the filing of an application notice prior to a deadline stops the sanction being imposed. But obviously, legal issues are not determined in a vacuum, and we have the judgment and the consequences of the judgment. And so, if I may, I would like to start with the ratio of the judgment and why we got the decision that we did, before I turn perhaps to whether or not this was a relief from sanctions application or not. My learned friend has done a sterling job of taking this court through the various pieces of evidence, and so I'll rattle through them, if I may, without taking my lordships to the evidence in detail. I would submit the starting point is the judgment. Core bundle, it's tab 7, for those without tabs, it's page 67. The ratio of the judgment is paragraph 7 and 8. And whilst the judge readily considers the lateness of the application to be one of the factors, he does not view that as the only factor, or the assailing factor, or the reason why this is relief from sanctions. But the judgment is the defendant has not conducted litigation efficiently and proportionately. It's actually been conducted to a standard that fell below that which one would expect. That's paragraph 7. I'm paraphrasing, obviously. The Lordship has already taken to it. He weighed the fact that if he didn't grant relief, the defendant would not be able to call evidence, but said, I think that that doesn't trump the poor conduct or the importance of the rules being enforced.
That's all in the context of an application of CPR 3.9, isn't it?
My lady, yes.
Yes. So if he was wrong to apply CPR 3.9, then we're in different territory.
If he was wrong to apply 3.9, then yes, we are. But it was still, as I'll come to, a conclusion that was open to him and which was right on the evidence.
And of course, 3.9, I'd be interested to know what you say about paragraph 2. It seems to me that reading paragraph 3.2, that he is treating the application issue date as being the key, rather than the date on which the application was made. And so he seems to be saying we're into 3.9 territory because this application wasn't issued until the 5th of August, which is after the deadline for service of the witness statement.
That's my interpretation too.
Yes.
That for the purpose of...
That's very fair.
For the question of does an application stop the sanction being imposed, he's effectively saying that doesn't matter because the application wasn't issued. And I'm taking the issue date as being the date upon which I should consider the application as being made for these purposes. We're using, as my learned friend pointed out, various terminology, and the problem is the CPR uses various terminology, and it's not perhaps clear. But yes, I readily accept. But he was invited to do that.
Was that wrong, though? I haven't quite got your case yet. Was he wrong? Do you accept that he was wrong well, he was obviously wrong in fact to say that the date was the 5th of August. We all agree that now. But was he wrong as a matter of law, do you say, to be looking at the issue date at all? Or should he have been looking at the made date, received date?
So,
it's a matter of law.
as a matter of law, for the purposes of an application, and I'm very clear it's an application, not originating process for the purpose of limitation, it's the date of issue that is important.
So you say for an application it's the date of issue.
Really? What's the authority for that?
Well, that I wasn't planning on spending much time on today because
it seems to fly in the face of most of the recent decisions of this court in relation to the timing at which things are brought or made.
So I was looking in the sorry, I'm in the wrong bundle. I'm looking for the authorities bundle.
Because if that's right, the issue date can often be a matter for the which can cause delay because of delays within the court process. And the general jurisprudence of this court is that once somebody has to do something and they bring it to the court's attention by making their application, filing their application, they've done everything that's in their power to start the ball rolling, so to speak.
Yes.
And delay is not to be regarded as something that can be laid at their door, and therefore the date from which time starts to run, or stops to run, depending on which sort of application you're looking at, is the date on which it's filed or made.
So, my lady, I totally and utterly agree with that in relation to limitation. I was relying upon the authority I quoted in my skeleton argument. I'm trying to find, I haven't marked it up because I wasn't planning on taking my lordships to it. My lordships will just bear with me till I find it. So it's the case of Collier and Williams Glass. The authority, hopefully in the authorities bundle, is the first authority. The decision reported in the first volume of the Weekly Law Reports for 2006.
That's all to do with service and claim forms.
And at paragraph 80 of that, page 9 of the bundle, essentially just in between D and E, we are in no doubt that the application is made when the notice is issued, not when it is heard. Now, it may be...
Well, they're not addressing at all the question of when the notice was filed.
No, but it's not a question of whether it's filed or not that in dispute, it's when it was made.
Yeah, well...
So my Lord asked for authority for that proposition. I accept it's not perhaps the most persuasive.
My lady asked for
I'm
it,
sorry.
actually.
But the issue here, it was a different discussion. It
Yes.
was whether you make your application at the point where you come to court to argue it, or whether you can be said to have made your application at the point you put it into the court process.
And we're talking about putting it in the court process and the authorities...
Yeah, we're on a needlepoint point, which is, we all agree it's when you put it into the court process. And I suppose my question to you was, and your response to me was that if you're dealing with an application, it's the date of issue which stops time running, or which is relevant. You've taken this is a case on a different point. Is there anything else? Are you maintaining that submission?
So I maintain the submission on the basis of what the Not in relation, I can't actually, thinking about it, because of the practice direction in force at the time was the pilot, and that effectively said that the date of issue for the application notice is when the fee was paid. The relevant practice direction is in the bundle, that's the authorities bundle, it's tab 9, and it's essentially paragraph 5, which is at page 152. And if one looks at paragraph 5.4, one where payment of a court fee is required to accompany the filing of a document, the date and time of filing electronic working will be deemed to be the date at which payment of the court fee is made using electronic working.
And that's because it's all supposed to happen at exactly the same time. And when we looked at this, it's in the application.
Yes. And so in relation to a claim form, I accept there are not more lax, but slightly different rules that allow essentially a claimant to have done everything possible to get their claim issued.
What's the legal justification, Mr. Brindle, for drawing a distinction between the time when you make a claim and the time when you make bring a claim and the time when you make an application to the court? What's the legal justification for it?
I'm not sure I understand the question. I'm so sorry.
Well, you're saying that there is a different rule which applies when somebody brings a claim. It's very well established that the time for bringing a claim, for limitation purposes or for any other purposes, is when the documents are filed with the court office. That's now well established.
That is contained in the Limitation Act itself.
Yes, but the word is brings, and that is a unilateral action on the part of a claimant,
Yes.
right? They bring it. There's been a more recent case called Escanda, which says that is also the case when one launches appeal processes. So when one files a notice of appeal, that's the date when the appeal is brought. And I'm asking you, what is the justification for treating the making of an application for, let's say, an extension of time or any other relief differently from that rule? What's the legal justification for the distinction that you seek to draw?
I see. So the application has to be properly made, and there's no exception for things like paying the appropriate fee for applications. The application is only made properly when the appropriate fee has been paid and the application is properly sealed. Would it be the case that if I prepared an application and went to the court office in this building today and simply threw it across the desk, that it would be deemed as been made at that point?
Well,
I would say
first of all,
no.
you can't do that anymore.
No, but
But by analogy with the way in which these matters have recently been dealt with, the answer is that the payment of the fee has got nothing to do with it. As long as the application is lodged with the court, that is the date on which that application is made.
so, my lady,
And the time at which it's issued, which is a matter entirely for the court process, is different.
my lady, I would have to say there has to be some formal acceptance by the court. So, for example, under the electronic filing pilot, although the date of issue is said to be the date of payment of the fee, the wording is very clear about being submitted and there being a subsequent acceptance. It's only if it is subsequently accepted that the issue is said to be when it was received.
I mean, it may not matter in this case because it all happened on the 4th. Do we have any evidence as to when the fee was paid?
Well, we do now. It's looked into, and it's exactly as per the effect of the electronic rules then in force, which is that it's all simultaneous. I mean, with the way that it practically happens is that someone presses send.
Yeah.
And
It all
all
goes
at the
through.
same time, their details, it's all in the rules. They have to log on, put in their solicitor's firm account number, and then it's deemed paid. And then, in fact, the way it works is that then that fee is effectively owing to HM Courts, but it is deemed paid at the point that it's submitted. That's in the practice direction.
What I'm really interested in is why there is said to be a distinction between applications made in the ordinary course to the court day in, day out, where it's, Mr. Brindle says it can't be made until the court issues it, and every other case in which it's made when it's filed.
Well, perhaps, my lady, I will not be able to persuade you of that.
No, I'm just interested because I'm genuinely interested in knowing what the rational justification for the distinction is that you say that there is.
So my belief is there has to be some kind of transaction between the party wishing the application to be issued and it being received by the court.
Well, that can't be right because lodging an application is non-transactional any more than issuing a claim form is transactional.
But the exception for claim forms is a specific exception within the Limitation Act. There's none. That's not for the no applications. Although I do accept 23.5 could be interpreted as supporting my lady's view on it.
Yeah.
And then there is the subsequent case of Iskander, which you may be forgiven for having missed because it's only 31st March. But in that, Lord Justice Nugee specifically says, paragraph 90, that he sees no relevant distinction between the analysis applied by my lady, Lady Justice Andrews in Siniakovich, the issue of a claim form, as it would be in relation to an appellant's notice, and I think one might therefore say, or in relation to any other type of application.
Then I fear I will not be able to persuade the bench otherwise. But as I said, I hadn't thought that I would need to trouble the bench with this point. I wanted to...
I suppose I'm sorry,
No.
What I still am not really clear on is your case. What I want to know is whether you accept the judge made an error of law in looking at the issue date of the 5th of August.
So,
as he saw it, as everybody was proceeding.
so if the evidence that we now have was before the judge at that time, then yes, I would accept my lady's proposition that he made an error of law in treating the 5th of August as the date on which the application was made. And I used made to try and cover
All right. Yes.
everything. At the time, the only evidence he had before him was the actual application notice itself that bore the date, the 5th of August, and the second statement from Miss Seabrook, which was saying that she had sent it to the court the day before.
I don't want to split hairs about all of this, but actually the application notice is dated 5th of August on the front cover, but the statement of truth is dated the 4th of August.
Yes.
Covered two dates on the same document.
Exactly. So it could have been signed on the 4th but not submitted to the court on the 5th.
Yeah.
And that
Because
is...
it might have alerted, had the point not been conceded, perhaps.
Well, and that's the next point I make. The judge wasn't actually invited to consider this. He was invited to treat this as a relief from sanctions application. Yeah. And in the skeleton argument submitted by the defendant at that hearing, it expressly says, and if you do so, we won't have cause for complaint. And yet now we're here, cause for complaint about the very step and presumption that the defendant said it wouldn't object about. So to criticise the judge for getting the wrong day on the application notice is unfair to the judge. The only evidence before, well not the only evidence, the evidence before him was confused. The actual notice itself said the wrong day, and the defendant didn't push the point and actively encouraged him to proceed on the basis it was made on the 5th. What I was hoping to expand on was the reasons behind the judge's judgment. It wasn't simply that this was an out-of-time application, therefore for not having relief. What he said was it was the conduct of the litigation in whole that led him to his conclusion. And if we look at the order of the Deputy Master Fine, which is in the supplemental bundle at page 2, behind divider 1. The learned judge effectively set 3 deadlines. Disclosure, 14th of April, witness statements, 7th of July, and questions to experts, 11th of August. We'll come back to this, no doubt, this order. But it's fair to say that none of those deadlines were met by the defendant. Disclosure, he sought an extension to May, that was 12th of May, that was agreed. We then saw further disclosure on the 18th of September, the 14th of January, and the 6th of February this year. And that disclosure was against a background of poor pre-action disclosure, which is set out in Mr. Riley's first statement, which is behind divider 9 in the supplemental bundle, page 31. On page 33, Mr. Riley sets out the substandard nature of the pre-action disclosure. Paragraphs 8 through to 16.
Remind me, please, which this is Riley 1, you say?
Yes. Supplemental bundle behind tab 9, page 33.
Oh, I'm sorry, I was looking at the wrong bundle. And that witness statement was made in relation to some earlier application, was it?
So that was made in relation to the claimant's application for the injunction and to strike out parts of the witness statement that the defendant has eventually served.
Yes.
And it's probably worth pointing out at this point that if it hadn't been for that application, the defendant's application for relief from sanctions would have come to be heard by the trial judge on the day of the trial.
This is the witness statement which said in paragraph 57 that the claimant's stance was neutral.
Well, there's more to it than the bench was taken to, but I will promise to take the lordships to it, ladies and lordships to it. But so from a procedural point of view, pre-action disclosure was poor, compliance with Deputy Master Fine's order as to disclosure was poor. Service of statements was extended to 4th of August, as we've been discussing. At the time the order was made, the defendant was given 4 months, from March till July. It was extended by a further month by agreement, and then the defendant sought a further 3 months, so effectively sought to double the time that had been allowed. And then questions to experts. In the application itself, the need to extend time for questions to experts was simply an afterthought. Simply, well, there'll be a consequential need to extend. The court's asked to do that also. That's the first statement of Miss Seabrook. That's at tab 4, page 15 of the supplemental bundle. And it's page 17 of the bundle, paragraph 16.
So the point she's making there is that that extension wouldn't have any impact on you, or the existing timetable in relation to yours.
And my lady, I think the claimant has been very clear in accepting that he can't point to prejudice. Mr. Riley's been very clear about that. But nevertheless, the application was seemingly filed on the basis that it would just be a matter of course and that the court would grant it, and that the defendant didn't really need to explain in any detail as to why doubling the time ordered by Master Fine was necessary. In any event, the questions were served 3 months late, and included with them copies of witness statements for which the defendant did not have at that time, and still doesn't have permission to rely upon. It's against that procedural default and that conduct of the litigation.
These are the witness statements that you object to, so it's not they don't have permission to rely on them, it's that you have made an application to strike out certain parts.
So as
not
things,
yet been adjudicated.
well, as things stand, the defendant does not have permission to rely upon those statements.
It has served well.
It's
Because there's no relief from sanctions.
And because that's the effect of Master Fine's order. And the effect of the judge's order, and the appeal doesn't stay the judge's order. The judge has not granted an extension. The defendant does not have permission to serve statements out of time. The statements served, therefore,
It was the out of time.
are not evidence in the case.
That's what I understood, yeah.
So to simply say, well, the judge just focused on this being an out-of-time application and he was wrong to do so, ignores the actual ratio of the judgment, which was you can't conduct litigation like this. The Wolf reforms and the Jackson reforms were designed to stop conduct of litigation in this manner.
Well,
And the reason given for why doubling of time for service of witness statements was necessary in the first statement of Ms. Seabrook is surprising. If I can invite the court to look at page 16 of the supplemental bundle, and it's paragraph 10. This is the only passage as to the explanation.
Sorry, can you just repeat the page number?
16.
Thank you. Back on the same page.
Whilst it is agreed that an in-person conference will be necessary in order to progress this matter further, logistical issues have arisen in that the defendant's specialist offices are based in Kent, whilst I am located in the northwest. Attempts to arrange the conference ongoing for approximately 3 months, however, despite these efforts, due to officer availability and officer training commitments, the conference is unable to take place until September. Using your legal representative's geographical location as a reason why you can't comply with a court order is a surprising reason to advance, I submit. And is, as the judge observed during the course of the hearing, almost akin to a solicitor taking on too much work that was frowned upon in Denton. I'll come back to that. The reasons in Miss Seabrook's second statement essentially amount to it's a military base that's often used by Ukrainians, and therefore we have difficulty getting access. And that are the sum total of the reasons before the judge. Legal advisors, geographical location, officers not being able to meet because their commitments wouldn't allow them, so effectively the defendant not allowing its own officers to meet with its legal representatives, and it's difficult to get access because the place is in use.
Of course, if this application had been heard earlier, rather than after the extended date which was requested, it would have been open to the court to say, well, you're asking for effectively double the time, but we'll give you an extension, but it'll be a shorter one. Problem was that it wasn't listed until shortly before the trial, by which time all the witness statements had been served.
It was asked to be dealt with on paper, actually. There was never a question of listing of this application, but no judge seems to have got to it.
And it took the claimant solicitors an awful lot of badgering, I would perhaps use this advisedly, to get the matter listed a week before the trial, so that it could be resolved. Now, I'm not sure that my ladyship is suggesting that that's a part of the fault of the claimant.
No, I'm not suggesting it's anybody's fault. I'm just saying that it is what it is. That the fact is that had it come on for a hearing sooner, or if it had been placed before a judge for consideration on the papers sooner, one way of dealing with the objection that they're effectively buying themselves far too much time by doing this would be to truncate the extended period. But that wasn't an option because of the way things panned out.
Yes. Yes. It has been suggested that the claimant has expressed neutrality throughout. Well, in actual fact, the claimant did was ask for what's the reason initially, and then said nothing more until the statement of Mr. Riley in December.
Paragraph 57 of that statement is pretty categorical, isn't it? Says it's not going to be opposed.
So, if I can refer the court to page 39 of the supplementary bundle, which is behind tab 9, this is Mr. Riley's statement. Paragraph 45 deals with the fact that the statements have been served late. 46 sets out the claimant's position. This is a relief from sanctions. Over the page. Should permission and relief be granted, the claimant will object to various passages of the statement. It's not saying that we consent. And over the page on 57, we accept, so the claimant's stance is neutral on the application, and I underline in principle. It's not saying unreservedly neutral, or has nothing to say. We're in principle neutral, but it's got to be subject to the fact that there's inadmissible evidence in them. We don't point to prejudice.
Well, then the next sentence.
So, yeah,
If the offending passages are redacted, the
Redacted.
claimant can't point to any prejudice.
yes, we can't, exactly.
Relief should be given
Cause-
only on the basis that the offending passages
Passages
are
are
redacted.
redacted.
Yes, so we're not saying relief should be granted. We're saying that if relief is granted, it should be on the condition that the passages are redacted.
Well, what it's not saying is we're opposing this.
So,
Neutral means neutral.
and as I say, I must go into an argument. If the claimant had said nothing about this application, the need for the defendant to persuade the judge to grant relief from sanctions would have remained the same.
Assuming it's a relief from sanctions case,
Yes.
yes. If not, the need to persuade the judge to extend time would have remained the same.
And so, the claimant's neutrality, if it is that, is but one factor when the court considers all the circumstances.
What you wouldn't have had was your reliance on all the various defaults that you say that there were in terms of other aspects of case progress, such as the failure to give disclosure and the need for the extension of the questions to experts and so on.
Well, again, lady, I'm really sorry, I didn't quite understand the point.
Well, yes, they would have had to persuade the court to extend time or to grant relief from sanctions, but if you remain neutral, this isn't a criticism because you're entitled to change your mind, but if you had remained neutral, the judge would not have had argument from you saying, well, you shouldn't grant them relief because look at how badly they've behaved, I paraphrase, in relation to the conduct of the case up to date. So all of the things that one sees in paragraph 7 of the judgment, either the judge would have to have rooted that out for himself, or they wouldn't have come to the fore at all.
So, I agree entirely with what my lady said, but I also say this in response to my learned friend's submission that the judge should have rooted through the CE file and found out himself when the application was actually issued.
Oh no, I mean...
it can't go both ways.
No, I mean the position is that for whatever reason the judge didn't have the full picture, which we now know.
But he didn't have the full picture only in respect to one aspect of the matters that he had to consider. And that was the day upon which the application was made.
Yes.
He had the full picture in relation to everything else.
But if the day on which the application is made matters legally as to which test, then it's a pretty crucial point.
And we shall come to that. As I say, I see that as the legal point in this court. However, the other factor the judge took into account was the fact that the application was made at the last minute, in croaking terms. Essentially on the day that the deadline expired. And when the witness statements were finally served, they contained inadmissible evidence. And the judge was very scathing of the statement of Mr. King, containing pseudo-expert evidence. And quite frankly, the defendant approached its application on the basis that it would simply be approved. My lords have been taken to the letter Miss Seabrook wrote on the 6th of February, that is at tab 12 of the supplemental bundle, page 183. My lords were taken to the second page of that letter under the heading Defendant's Witness Statements. And the fourth paragraph there, at this point we're dealing with preparations for the trial bundle, and the defendant and the claimant is saying, we're not including your statements because you don't have permission to rely on them. The defendant in the fourth paragraph says, please include the statements of the trial bundle. There is no question that the court will permit the defendant to rely on the same.
All right, they were complacent. They were proved wrong. So what?
It's a factor that is relevant in all the circumstances.
Why?
Because as the judge said, he was not satisfied with the second statement that Miss Seabrook prepared being sufficient for the purposes of the application. He described it as a lazy statement.
Well, that's because he saw it as an application for relief from sanctions, so we're going round and round in circles.
Well, then perhaps I should address the court about why this is relief from sanctions so that my points perhaps make more sense. But what I will come back to the point about the judge was encouraged by the defendants to adopt this approach anyway, and it's now not fair to criticise him for that. But I submit the starting point on the question of whether or not this is a release from sanctions is to identify whether there is a breach of a rule, practice, direction or court order. And if that breach results in a sanction being applied. Because if it does, then this is a relief from sanctions case. If it does not, then it is not, and I accept that. The starting point is Deputy Master Fine's order. That is page 3 of the supplemental bundle. Paragraph 4 of the order, subparagraph C. Oral evidence will not be permitted at trial if statements not been served in accordance with this order or has been served late, except with permission of the court. There is no dispute that statements were served late.
Well, he didn't
But
actually
hold on,
need to.
I wanted to pick away a little bit of that because
Yes.
the date that the judge gave was the 7th of July,
Yes.
which was extended by consent. So everybody agrees, don't they, that what the judge writes here is only subject to what then might I mean, you could certainly agree to extend this. It's not like this is written in stone forevermore, because you did agree to extend at least to the 4th of August.
Yes.
So isn't the issue, what is the effect on this order of issuing an application, let's say within time for the purposes of argument, so before you get to whatever it is, 4 o'clock on the 4th of August, whatever the magic moment is, does that operate, does that give you protection, if you like?
Yes, that's the question. I totally agree. That's the question.
Is whether the issue of an application protects you against sanction.
And there is an answer to this. It's in the CPR. So the sanction is you're not allowed to call oral evidence if you serve late. There's no dispute that the statements were served late. The only way around that is for the defendant to convince you that the in-time application stopped that order from operating. The CPR also includes the same
32.10.
32.10.
The Deputy Master didn't need to say it. It was in 32.10 anyway.
Yes. And so the same question arises. Does the making of an in-time application stop 32.10 operating?
Well, it must do, because if the relief is granted and the extension of time is given, then the witness statements won't be served out of time.
So the answer is found in CPR 3.8. I'm going to invite leadership to view that. One, where a party has failed to comply with the rule, practice, direction, or court order, any sanction for failure to comply imposed by the rule, practice, or court order has effect unless the party in default applies for and obtains relief from sanction. So the mere application is not enough.
You say both of those things have to be within the deadline, do you? So they both...
No, I don't say they both have to be within the deadline, but the sanction has effect.
Yeah.
Unless we accept that. And the unless has two parts. You've got to make an application and you've actually got to get relief from sanctions.
When?
So when you've got to make, well, it doesn't matter.
Now, when do you have to get the relief from sanctions? My lady's right, because on your construction, you'd have to do it all before the 4th.
No, I'm not suggesting
Otherwise,
that.
you'd be out of time.
Otherwise you'd be out of time.
No, I'm not.
Or you'd say you're in default when you put the application in.
Yes.
You stop being in default when you get the relief.
Yes, that's exactly it. That is exactly it. You don't stop being in default when you make the application. The rules are very clear about that. And I'm not suggesting that the rules are saying you have to have made the application and it for it to have been heard. What I'm suggesting is the way the rules work is you're in default until relief is granted, and then you're deemed to have been...
Well, if I can see that that's a potential way of reading it, but then there would be quite a lot of jurisprudence at this court's level which would be wrong, including the case that your opponent cited to us this morning.
Well, that's why I say it's wrong. Because, see, I can take my ladyship to Housekeeping Estates in due course, but that was decided in 2014, and Lord Justice Jackson expressly says in the judgment, we still need to work out some of
It was decided in 2014.
some of the kinks in
It said
3.9.
that the new CPR didn't make any difference. It was then approved in Denton and White, and it has been followed by this court on numerous occasions since.
So, my lady, I invite the court to consider how else 3.8 can be interpreted. It is very clear that if you are in default, the sanction applies unless
Well, it begs the
things.
question of whether you're in default. If you make an application for an extension of time, it can't be said that you're in default until that application is determined.
That's not what.
That's the way it operates.
I would humbly suggest that is straining the clear words of 3.8.
Well, it's the way in which 3.8 has been interpreted by this court.
Then again, I would humbly submit that that's not how it should be interpreted. And I also submit I'm not entirely in agreement with my ladyship that that's how this court has interpreted it. And on that, I will take my ladyship to the authorities that I've referred to. So the FANZA authority, this is the authorities bundle, tab 7. We have the two decisions, so there's two judgments. We'll just disperse. And it's really paragraph 20 onwards that deals with this. That's at page 126. And at paragraph 20, he sets out, sorry, my lord sets out paragraphs CPR 3.8 and 3.9. Paragraph 21 says these rules do not create sanctions but apply when a sanction exists. Rule 3.8 operates to make clear that when a sanction is provided for, there is no need to come back to court for an order imposing it. It takes effect and the onus on taking action is the other way around. So this court has interpreted 3.8 as operating in the way that I suggest.
No. Look at 127, letter F. The characteristic feature of applications for relief of sanctions is the fact that the application arises in circumstances in which the sanction is already properly in place and the applicant is seeking to disapply it.
That's what my Lord Justice Burse is saying in paragraph 21. So, drawing a distinction between applications under the overriding objective and under 3.9 is what my Lord is doing in paragraph 23. What he's doing in paragraph 21 is saying how sanctions come to be imposed. And they take effect the moment they are breached.
I have a conceptual difficulty with this, which is this, that the sanction is treated as effective on your analysis, notwithstanding that there is an application for an extension of time, which can't be heard or determined before it takes effect. And therefore there won't be a distinction between making an application in time or making that application out of time. However, if the court grants the relief, there is in fact an extension of time and there's no breach.
Yes?
So how can you both have a sanction and no breach?
So until relief from sanctions is granted, the party in default has no permission to call oral evidence at trial. That's the effect of the sanction. They then make an application, and I accept it matters not for whether the application should be treated under 3.9 or not, when it was made, but it certainly makes a difference to the circumstances when the court comes to consider them.
If an extension of time is granted, which is what they're asking for, then the time for service of the witness statements is no longer the 4th of August, but the end of October. And therefore the 4th of August is treated as a totally irrelevant date for the term, from the terms of service of the witness statements. and the time at which any sanction for non-compliance will bite is the end of October. So if an extension of time is granted, and that is an application which might be made and might be agreed or by the court, how can one treat a sanction as operative until that application has been determined?
In the same way one treats limitation arguments. The claimant issues the claim form outside the limitation period. Until the court exercises its discretion to allow the claim to proceed, the claim is statute barred. Section 33 limitation. It's the same logical analysis that until the court exercises discretion in the applicant's favour, the sanction is in place. But when it exercises its discretion in the applicant's favour, then it makes orders as to how the sanction is no longer applied. So in the example a lady gives, if this had been heard and the judge had said, I extend time, a very Deputy Master finds orders so that the service of the witness statements is by the 30th of October. That's been done, no sanction. It's retrospectively changed the order, retrospectively removed the sanction.
It's varied the order in such a way that there is no sanction until the varied order is breached.
Yes.
So there is no default, that's the point.
But
The point is there is no default.
But that's as a result of the court order. That's the result of the court exercising
court order extending time, and that's something fundamentally different from an order seeking relief from sanctions, which is when your time has expired, and then you go back and say, can I have an indulgence of the court to relieve me from the sanctions otherwise imposed?
But that's where we are. We're discussing, I submit, whether the sanction bit at 4 p.m. on the 4th of August, regardless of whether or not the application was made before that date. And I submit, if one reads CPR 3.8, it does. It is very clear that it does. It takes effect, and it remains in effect until those two conditions are satisfied. An application is made and relief has been granted. That is what Lord Justice Burse says in paragraph 21 of the stanza.
Right, well, shall we pause there until 2 o'clock?
Court rise and table.